Good evening and welcome to another one of the Tenant Farmers Association's webinars. You're very welcome, whether you're joining us live tonight or on catch-up. My name is George Dunn. I'm the Chief Executive of the Tenant Farmers Association, and I have the pleasure of being your host this evening. So this is the second part of a two-part mini-series on farm rent reviews. We held the first part of the mini-series last month on the 11th of February. And in that part, we focused on preparing for a rent review and responding to a landlord's proposals before thinking about the arbitration process if that was needed. So if you missed that first part, don't worry. You can catch up by accessing it on our YouTube channel, and more about that in a moment. So tonight, in part two, we will be looking at preparing for a rent review arbitration, which will follow the breakdown of negotiations between a landlord and the tenant. And we have two expert panelists who will lead us through this topic tonight, and I will introduce you to them a little later on. But before we get going, I'd like to say a big thank you to our event sponsors, and that's Roythorns Solicitors. Roythorns are kindly sponsoring the TFA virtual events and knowledge share videos right the way through until March of next year, March 2027. And those of you who don't know Roythorns, it is a national firm of solicitors. They are steeped in agriculture, over 90 years experience advising landowners and tenant farmers alike. And their lawyers are also very active in farm tenancy policy forums, so they do get the bigger picture. So whether you are looking at a succession application under the Agricultural Holdings Act, or a new farm business tenancy, or a dispute with your landlord, a share farming agreement, or even a newfangled natural capital agreement, Roythorns will be able to help you and to assist. So if you miss any of our webinar tonight, or you just want to rewatch it, and I would recommend you rewatching it, particularly alongside part one. We are recording this. It will be edited, and then it will be available on the TFA YouTube channel. And to find the YouTube channel, just search at Tenant Farmers. Our video library features all of our past virtual events, knowledge shares, and teach-ins. And we would certainly encourage you to pay a visit there and then subscribe to make sure you're notified when we upload new content. So as I said, just search at Tenant Farmers and you'll find that channel. We will be doing an interactive question and answer tonight with our two panelists. So if you want to ask them a question, please put something in the Q&A chat, and I will try and pick it up as we go this evening. I can't promise to get to all of the questions that you ask, but I will do my best to get to them. So please put anything that you have you want to ask in the Q&A box, which you'll find in your Zoom toolbar. So without further ado, let me introduce you to our experts, and I'm so glad they've decided to come back. They were with us last month, and they're going to help us with this really important topic. So our first expert is Ellie Allwood. Welcome, Ellie. Ellie is divisional partner from Brown & Co. She comes from Nottinghamshire, and she comes from a farming family. She was previously a partner with J.H. Walter, and she joined that firm back in 1994 and was with J.H. Walter until the merger with Brown & Co. in October 2021. She's now a divisional partner in the Brown & Co. Lincoln Land Agency team, and her specialisms are rural landlord and tenant, particularly under the Agricultural Holdings Act 1986, the Agricultural Tenancies Act 1995, and all associated landlord and tenant matters, including rent reviews, disputes, surrenders, successions, and happily, and good for us, Ellie is also a rural arbitrator. Secondly, we've got Edward Briggs. Edward has 37 years experience as an arbitrator, mediator, RICS accredited expert witness, and independent expert. And he sits on the RICS Dispute Resolution Services panel for arbitrators, independent experts, and CPO dispute resolution, dispute resolvers, that's compulsory purchase orders. So as well as the CAV panel of arbitrators, before founding Briggs & Stone, Edward was managing partner of Bidwell's Rural Division and he now works across England and Wales, specialising in rural valuations, landlord and tenant matters, dispute resolutions, and strategic estate advice. And happily for us as well, Edward is also an arbitrator. So both Ellie and Edward are well able and well capable of answering our questions tonight. So why are we doing this? Well, with farming profitability under severe pressure and the recent events in the Middle East likely to drive that pressure even harder, particularly in the arable and in the dairy sectors, we have many TFA members who will be looking at whether it's appropriate to consider arguing for a rent reduction. And this mini-series of 2 webinars is an attempt to provide some insight for members and others into how rents are reviewed, and what might happen if the negotiation has to be settled by arbitration, which is the focus of tonight's webinar. So we are using a constructed example to assist with the explanation of this process. And if you missed our first webinar on this, I'm just going to run through that constructed example now so we have that in our heads. But Julia, our communications and events coordinator, will also be putting a link to that in the chat so you can get that as well. So we're talking about an imaginary farm called Hawthorne Bridge Farm. It's a 350-acre mixed holding. It's in the West Midlands, rented under a full Agricultural Holdings Act 1986 agreement, originally granted in 1978, and the tenant, Mr. Jonathan Price, is 68, and farms in partnership with his daughter, Emily, 34, who lives with her own young family in a self-contained annex invested in by the tenant and attached to the farmhouse. There are succession rights, but they haven't been triggered yet. No succession applications have been made. The holding is made up of 235 acres of arable, winter wheat, barley, oilseed rape, and rotational grass, 100 acres of permanent pasture, upon which there's a lowland sheep flock, 15 acres of woodland and rough ground. There's a 5-bedroom farmhouse, which is divided into the main dwelling occupied by Mr. Price, and the annex, as I've said, occupied by Emily, her partner, and children. They are tenant's family, not sublet. Emily works on the holding on weekends, mornings, and evenings, in between her part-time off-farm job, and does liveries around her part-time job as well. There's a traditional courtyard of stone barns, landlord's fixed equipment, a modern livestock building, 2 cottages, one let on an assured sharehold tenancy. There's a grain store, a women's shed, and the assured sharehold tenancy is with unconditional written consent. The farm supports a small livery business, 6 DIY and 4 full liveries with unconditional written consent. There's contracting activity, hedge cutting, and drilling for local farms, and the holding has some issues, as you won't be surprised to hear. So there's severe game damage to the arable crops caused by the landlord's sporting rights, which are utilised by a third party, and the landlord makes it quite difficult for the tenant to make the annual game damage claim, and the tenant feels bullied into keeping quiet. The landlord won't engage in getting extensive and much needed repairs done to the farmhouse and the traditional buildings for which they are liable. The tenant claims a sustainable farming incentive over 150 acres. He has an HLS claim, which has recently been extended for a further year over 75 acres, and it's predominantly grade 3 land with some arable areas are grade 2. The current rent is £29,750 or £85 per acre. That's per year, and it was last reviewed back in 2019. The landlord served the rent review notice, and the tenant's agent has come to the tenant just 1 month before the rent review date, demanding an increase from the £29,750 to £35,000 or £100 per acre. And they state that if they don't agree to the increase, they have to pay for the application of the RICS for the appointment of an arbitrator on the basis that they are not agreeing to the reasonable increase based on market evidence. The landlord's agent has provided no budgetary evidence, minimal information about the comparables upon which the landlord will be seeking to rely. And the landlord's agent has also told the tenant that the other farmers on the estate have agreed to a proposed increase to £90 per acre, and that this evidence is more important than budgets. The landlord's agent also states that they have applied a higher figure for the rent for the farmhouse on the basis that the tenant's daughter and her partner are living there independently, And whilst they do help on the farm, they have careers away from the unit. That's a lot to take in, I know, but you can pick up the scenario. We wanted it to be as real and authentic and with lots of issues going on as possible. As I say, in our first webinar, we talked about how to prepare a rent review. With all of that in the background, we certainly recommend you go and watch that. But we did leave the last webinar, Ellie and Edward, I think with both of you in agreement that the tenant shouldn't accept the landlord's proposal of the increase in the level of rent. And now we are looking at arbitration. So Ellie, let me come to you first, if I may. What is the process for appointing an arbitrator, and what, in a nutshell, is it that they will do? And can you just answer this point as well within the scenario where the landlord's agent is basically trying to get the tenant to pay for that application?
Well, I can answer the second part first, and it's a few letters involving off probably. But no, the landlord wants to pursue this rent review. So yes, I would say that the landlord has to pay that application fee. There is an application fee if you're applying to the Royal Institution of Chartered Surveyors, RICS, or Dispute Resolution Service within the RICS, or the Central Association of Agricultural Valuers to appoint an arbitrator, and that's £195. So it's not a little sum, but it's not the end of the world. But the landlord should pay that if they want to pursue the rent review. Beyond there, you have to make sure that the application is lodged with the RICS, and that can be done by email at the very last minute. We don't have to rely on the post. So if you're applying to one of the bodies to appoint an arbitrator, the application has to be in by the rent review date, and ideally the day before. If you're actually saying, well, we'd rather have Bob Smith act as our arbitrator because we know and trust him, or indeed Julia Smith because she happens to be, a lady, you can approach that arbitrator and say, could you accept this appointment? They have to make sure they have no conflict. They're not already directly involved with either party. And they have to accept the appointment, but they have to do that before the rent review date. So there is no application fee, but but you have to get that done and agreed in writing before the rent review date. If anybody's involved in commercial rent reviews, very often time is not of the essence is a phrase on commercial ones. So you can appoint after the rent review date, but that's not the same on agricultural tenancies. You've got to get that application in or the arbitrator appointed by the rent review date. That one.
Okay, so there's a few choices. You can either apply to the Royal Institution of Chartered Surveyors, or to the Central Association of Agricultural Valuers, or to the Agricultural Law Association.
Yeah, CALA, yes.
Yeah. Or you can appoint by agreement. Okay. So Edward, turning to you, which of those would you typically use? Have you used them all, or is there any which are better than others?
For rent reviews, I've either used the CAV or the RICS. The Agricultural Law Association tend to have arbitrators to deal principally with legal disputes and similar. So I mean, they do have surveyors as arbitrators, but I think surveyors are generally the best type of arbitrator to deal with a rent review. So I tend to use mainly the RICS because I suppose that's the default position, but we're using the CAV more and more now.
And what's the price for appointing an arbitrator these days to the RICS? Do you know?
The standard fees are £195.
Yeah.
£195.
Yeah. And that, I think that's set, Ellie, isn't it?
It is, yes. Yeah. It is, yes. There's no variation. It hasn't been reviewed for some years, but it hadn't been, and it's just recently gone up to 195. It used to be 115. That one, so yeah. Could we? Sorry, I'm jumping in, George. You may be going to the next point about using a DRS5 form. I think it's useful for people to understand what that means.
Yeah, crack on, Ellie. That's fine.
This is where you still make the application to DRS CAV or ALA, DRS. It's DRS application. If you're applying to the RICS to appoint an arbitrator, you may be asked to sign a DRS5 form, which is a form which goes to the RICS at the same time as the application to say, we are very close to settling. Please don't actually appoint an arbitrator. So accept the application. So the application is legal and in time, but the arbitrator is not actually appointed because it can be a concern that as soon as the arbitrator is appointed, and by which it could be a few days or a couple of weeks for the RICS to find an arbitrator and say you're now appointed, and that arbitrator issues their letter and their recording time. So there will be some cost to pay, 350, 400, 450, which somebody has to pay. Whereas if you put the DRS5 form in, then the RICS don't actually appoint an arbitrator, so there's no cost running. But they do only allow you a period of grace of, I can't remember, now 3 months or 6 months. And then they will chase and say, if you've not settled the matter, you either pay a further fee of £50 to extend it, or we will appoint. And that is to try and avoid people using this as some way of just holding the whole arbitration, not getting on with it, and the matter getting more and more difficult because you're moving further and further away from the actual rent review date. But if, as so often happens in rent reviews, you are sorting out other issues such as surrender of a cottage, changing some of the terms of tenancy, maybe even not actually really doing a rent review, talking about a surrender of the whole tenancy or something like that, it's quite useful then. But I have had landlords who have tried to submit this without actually asking the tenant to sign it, and they've slipped through. And the tenant's then left saying, well, I don't know what's happening. And there isn't actually an arbitrator being appointed, but it hasn't been agreed with the tenant. So you just need to be aware because if the application's gone into the DRS, you should get a letter. And it should be emailed out to you if there's an email address or written to you. I have had situations where the DRS haven't been supplied by an email with an email address from the landlord who's mysteriously forgotten, despite the fact they wrote the day before and then the day after by email. But there you go. And failed to tell the DRS. DRS didn't have an email, asked the landlord to let the tenant know an application had been made, and the landlord forgot to do that as well. So it's surprising when that happens, but it does. So there are some tactics out there which, if you get your tenant's agent onto it, will soon be stopped.
Okay, so just to recap to make sure we're all in the same space here. So before the rent review term date, the person who wants to continue pursuing the rent review has to make an application for the appointment of an arbitrator. That could be to the RICS, CAV, or the ALA, but you are both preferring RICS and CAV for a rent review type scenario. There is an option, but only if you apply to the RICS that you can have this option of putting the application on hold while you have a little bit more time for negotiation. That's what you're saying, and then the RICS will contact you within 3 months if you haven't moved things on. But let's say, Ali, what would happen if there was no DRS5, so there was no form to say the arbitrator should be put on hold. So an arbitrator is appointed, and you get a letter from the arbitrator saying, "Hello, I'm here. What do you want me to do in your rent review?" Even at that stage, if you need a little bit more time, what option have you got with the arbitrator then?
I think, and it'd be interesting to see where I'd take the same view. When I'm approached, I will tend to, my terms will say, can the parties just tell me what is the situation? Are there other issues being discussed here? Do you wish to have what is in essence a stay of 2-3 months? Because yes, we should all get on, and I'm sure you're going to come back to timing as well. But inevitably, there can be other things being discussed. So I tend to say, I want an update by 3 months hence, and I will tend to say, if it is settled by that date, and I've done no more than issue this letter, but I've held it open, there is a fee. And I will tell them what that fee is, and that uncovers me opening the file, deal with the paperwork, reporting to the RICS, but I'll actually do nothing. Other times, sometimes perhaps sometimes when you are appointed, it's a long way since the actual rent review date. That could be various reasons, because the appointing body has had problems finding somebody who's not connected with their parties. For example, the Crown Estate. Most of us have got tenants on the Crown Estate. So trying to find an arbitrator who can take a Crown Estate arbitration could be difficult. So it may take some time. And if by the time you're appointed, it's 2 or 3 months down the line, at that stage, I would be saying, come on, parties, you've had enough time. and I would then ask for a preliminary meeting and say, I just want to have an informal meeting by Teams, Zoom, whatever. Let's just hear what the issues are. So that's
So
what
I'll bring Edward in a moment. So just to be clear then, so that a tenant shouldn't necessarily fear the appointment of an arbitrator because it doesn't mean you end up at arbitration. You could have more time for discussion by the arbitrator offering you a stay before they do anything. Yeah. Edward, would you take the same approach as Ellie if you were?
Yeah, I think, George, it's fair to say that a very high percentage of my appointments get settled. It's only very few that end up going through the whole process. And the role of an arbitrator is to try and encourage that settlement. It's not to try and create disputes where none exist. And I tend to give parties, as long as I feel they're behaving reasonably and sensibly, then a period of time to get things settled. Sometimes you get a sense that one party's not engaging, and then you step in and say, right, we've got to get on with this. But if you feel that the parties are both making good progress and you sense there's a solution at hand, you sit on your hands and say, okay, you can have another month, and so on. And that seems to work, and that's why a high percentage get settled.
So sometimes the landlord will come and say, well, if we don't agree by this date, then we're going to arbitration. That hard stop doesn't really exist in reality, does it?
Well, in terms of saying to the arbitrator or to the
No, in terms of saying you will end up at arbitration if you don't agree by a date.
No. I mean, as I say, it's a very low percentage.
Yeah. Okay. And while we've got you there, Edward, we're talking about arbitration here, but obviously there's other ways in which you can resolve a dispute if you can't reach an agreement between you and the landlord here. Can you just briefly talk through what those non-arbitration routes might be?
Yeah, I think, well, arbitration has always been the traditional route, and an arbitrator requires evidence from the parties to make a decision. The arbitrator doesn't necessarily bring their own evidence into that. They obviously have to have the skill and knowledge, but it's the evidence. They determine the award on the evidence put forward to them. The alternatives, you can ask a dispute resolver to act as an independent expert, which would technically remove the need to submit evidence from either party, and the expert could, if they chose to, make the decision based on their own knowledge. Generally, experts invite submissions from the parties, but it can be a quicker and cheaper process to do it that way. And alternatively, you can have mediation, which is another route where you all sit in a room with a mediator who's a third party, who I suppose best describes engages in shuttle diplomacy between the parties. And mediation can be useful because you can quite often get other things agreed as is in that process, where the arbitrator will sit there and determine the issue of dispute in front of them based on the evidence. The independent expert is similar, but a mediator has that wider role of saying, well, have you thought about this or have you thought about that? And mediations are very successful, but they do depend on the parties being relatively close together, rather than if they're poles apart and entrenched, then mediation can have difficulties because it could be then difficult to move those parties together.
Right, Ellie, even within the arbitration route that parties might want to take, there's a couple of options, isn't it? Particularly if you go down the RICS route, there's a couple of options that you can use. One which might be a bit cheaper than the other. Can you just explain what those are?
Absolutely. There is the traditional route is shall we say full arbitration or traditional arbitration, but because there was concern that people were perhaps concerned about costs, overwhelmed by a bigger process, the simplified arbitration scheme was introduced. This is not, as I have had described to me, sort of a dumbed down version. You get the same arbitrators, but the difference is that from the outset, it is identified that it is a clear, straightforward dispute, maybe just about the rent. So we're not arguing about rent review repair clauses and who's did improvements, complex arguments. It's straightforward about the rent. And what it does, it limits the costs. It depends whether the arbitrator actually goes on site, whether they actually have a hearing or just have written representations. But it limits the costs to 3 or 4,000, depending which route you take. And that's the arbitrator's costs. And it means that both parties have to share those costs equally. Whereas in a full arbitration, I know we're going to come on to talk about how you manage that system. You could theoretically get your cost paid by the other side if you dealt with it tactfully, but those costs could be quite considerable. Whereas on a simplified, they're limited, but you have to pay 50%. And it will mean that the arbitrator will say, because it is the arbitrator can say, no, this is too complex. You told me it was simple. You're not keeping it simple. I'm going to put you into full. And as well as either party could say, no, I want to go into full. They may limit how many pages, how many documents. You certainly won't have 3 experts and 5 ring binders of information. You may say, right, I want a submission, counter submission, limited to 10 pages, so many words, nice and straightforward, and get it sorted. So it is definitely a route forward.
Edward, have you used the simplified arbitration route?
I've tried to, George, but the problem is, and it's a great idea, but the parties involved tend to go off piste. It does work when you have a compact submissions from one party and a compact submissions from the other. But then, as Ellie said, that then you can have a hearing and they suddenly want to bring in expert evidence and to give evidence. And as soon as you get into that role, you're departing from it. And I think there's a lack of understanding of the intention of the simplified scheme, which is a really good intention. But if we're going to use it, we have to stick to it. And it has to be, well, let's put in one block of submissions for each party and they can have a rebuttal of each party. Then the arbitrator, best by doing written submissions, just deal with it from there. But as soon as you depart from that and starting bringing lots of experts in, that's when the problems start. So the answer is I've started trying to do it as an arbitrator with all good intentions, but we've ended up going off piste on that and ending up in the full arbitration process.
I suppose it requires the parties to be quite focused on what the issue is they want to be resolved and not to bring those extraneous issues to play and to be very careful to ensure that they couch their remarks purely on that issue. Yeah.
Yeah, and I've just had an example. I've just settled an FBT rent of a very large FBT, and the landlord's agent wanted to use a simplified scheme, but then started introducing all sorts of other issues in relation to it and subletting and all those things, which were totally inappropriate for what we were trying to focus on, which was the rent review for the agricultural arable land on it. And we ended up we couldn't agree that, and the arbitrator was appointed on a full basis. And we got it settled, but it was clearly the right thing not to go down that simplified scheme. And all the landlord was doing was trying to get a cheap rent review.
Yeah. I think there's a question that's been raised in the Q&A, which you might like to answer. Edward's already said that perhaps the ALA is not the most appropriate body to be appointed arbitrators for rent reviews. But here's a question about solicitors. So the participant asks, what do the experts think about the role of solicitors in AHA and ATA rent arbitration proceedings? Should a tenant consider appointing a solicitor rather than an agent valuer to represent them? Ellie, what do you think?
I think the overall approach generally often is as a team, but I think my first question is say what is really what is the dispute about? As Edward has said, what is the dispute about? If it is purely about the rent, then with all due respect, I don't know what the solicitor will bring to it. If it is about interpretation of consents, the things, there could be, I think you'd need both sides of the team, but I would really question as to what you really think you're trying to do. Now, having said that, there can be issues where I've got at the moment where it looks to be a straightforward rent review appointment. That's what that's what the landlord is saying. but they served a Section 12 notice on the wrong tenant. They served it on the tenant and the wrong, who they say is the tenant. But only made one application to the RHS. So we're having an argument there. And I've got solicitors in the background there to bring in because we haven't even started talking about the rent. It was all about the trigger notice. So I think having a professional involved who recognises the limit of their expertise and then says, right, at this stage, we need relevant expertise brought in is good. Which does bring you round to having that professional advice, because I'm sure Edward's had the same, as where we act as arbitrators and people are unrepresented and do not understand the process or know that, for example, you can't speak direct to the arbitrator. You have to go, very helpful secretary, or it goes in writing. You have to copy it to the side. You do not have direct communications. And also understanding the role of the arbitrator, as Edward said earlier on, it's determining on the evidence put to the arbitrator. They are not the expert, and people don't always understand. And by people, sometimes it can be professional advisors who think the expert's the one just waving the magic wand and telling them the answer without doing any work, and that's not the case. So I think if you have got a professional acting for you, they will understand when to bring in somebody else, be that solicitor, or maybe it brings in a good consultant, soil expert, all sorts of different experts to come in, and what the arbitrator's role is and what their role is as well.
But sometimes we even find situations where the arbitrator wants to have a lawyer on their side, don't we? So we have a legal rep that sits alongside the arbitrator. I mean, that seems to be a bit bizarre in a rent review context, but sometimes it happens, doesn't it?
Yes.
Yeah, it happens. It comes down to, it's almost linked in with the previous question. I suppose from the starting position, you don't need a solicitor to deal with a rent review because it's not a legal matter. But inevitably, particularly on some complex holdings, legal matters arise of, for example, about who owns what improvements, all of those sorts of things. And then there can be complex areas of law that are raised in a rent review, and we as surveyors, we can take a decision about whether we feel we're qualified to address those points. And some I feel that I can deal with, but other things you think, well, actually, that requires some complex legal advice, and we're entitled, with the agreement of the parties, to appoint what's called a legal assessor, and it's an open. We give our instructions to the legal assessor in agreement with the parties, and when the legal assessor provides us with a legal opinion, we share it with the parties before we make the award to determine various things. And it's more common in things like notices to quit, but it does happen in rent reviews because there are complex holdings out there, and there are issues that require legal input.
Okay, so getting down to some of the brass tacks here. So you both said it's not for the arbitrator to bring their own evidence or to bring their own opinion into the arbitration process. So when a tenant is thinking about putting together their statement of case, so Edward, let's stick with you for the moment. What should a tenant be thinking about in terms of what they should be including in that statement of case and in the representations that they're making in order to make best use of this process?
Well, I mean, when we start off, we look at there's a process for the arbitration, which generally starts with the preliminary meeting, and following that preliminary meeting with the parties, which is usually on a Teams call such as this, the arbitrator gives directions about how he wants or she wants the process to be dealt with, and that will generally involve the production of a number of documents. The first will be the statement of agreed facts, which the parties are encouraged to produce a document reflecting things like the area of the holding, who owns what, when the rent review was dealt with, all of the things that hopefully you won't argue over. And then following that, in the context of that, generally the parties are encouraged to provide a statement of case, which is as it sounds, it is the reasons why there is a dispute and their skeleton arguments for their position of why they're adopting whatever rent they're adopting and the reasons why. And that sometimes can be prepared by the agents acting for them. Sometimes it can be prepared by a solicitor, again, depending on on the legal complexities. And as part of that, the statement of case should cover the issues that will be introduced by the expert evidence which the parties will produce. And that could be a farm management consultant on the productive capacity and related earning capacity of the holding. That could be a surveyor giving how he interprets that productive capacity to go back into the rent, how they deal with disregards such as tenants improvements and fixtures. And so the statement of case is the key document in which that refers to the evidence that they're going to be introduced, and that is accompanied by the expert evidence, and whether that is the valuer, the farm management consultant, in some cases the planning specialist, or whatever it might be. And so they all tie in, and that statement of case is exchanged with the other parties' statement of case. The witness evidence is exchanged, and generally there's then a position for each party to rebut the other. And then that will depend on whether it's going to be a hearing, which generally is in larger cases, or it's going to be dealt with by written representations.
So Ellie, would you have anything in addition to what Edward's just said there in terms of that material?
I would say that traditionally the statement of case is very simple, particularly done by agents. The solicitors, their skeletal arguments can be much longer. But I think it can often be the first time that people have really focused their mind on what are the issues, and it can also identify, well, yes, we're going to argue about the rent, but we want to argue about who put the drainage in, and have those drainage improvements roll from one tenancy to the other, and how we treat the joint expenditure on the grain store, etc. So actually really focusing on the statement of case can also identify some preliminary issues which, once they've been resolved, actually help things rolling. And it's not unusual for an arbitrator to be asked to determine preliminary issues. Then everybody draws breath, because the parties may go away and say, well, now we've agreed how we treat the drainage or whatever, we're now going away and talk about budgets or etc. So it can be very helpful to really focus the mind, because as in this scenario, if it literally is a month before settle on this rent with no explanation, no budgets, etc., there can be quite a few issues that haven't even been addressed until you get to that statement of case, or potentially in a preliminary meeting.
So we'll come to the budget in a minute, Ellie. But some of the issues on this scenario, we've had the concerns about the poor state of repair of the buildings and other fixed equipment, the landlord's refusal to do anything about that, and the substantial game damage problem that exists, and the fact that the tenant feels bullied into not putting in a claim. Obviously, the tenant's going to put that information into their statement of case. What does the arbitrator do with that information? Do they take it into consideration when they're settling the rent?
Yes, I mean the arbitrator is governed by Schedule 12 of the Schedule 2, Section 12, Schedule 2 of the Agricultural Holdings Act, or for the AHA tenancies, or by the FBT. So we can't go off on, well, we think this is fair. We are governed by what the Act says we have to take into account. And there are things that you disregard and take into account. And again, just to overstress, it's not our interpretation of how we think that should be treated. It's how the parties present to us how they think that state of repair, etc. So the state of repair, you do take into account if the landlord hasn't carried out repairs. The gain damage, the landlord may well say, well, you can make under an AHA, make a Section 20 claim for damage. But if you've got gain damage, the chances are that you're on a farm surrounded by other woodland, and you take into account the character of the holding. So it may well be different to somewhere where there is, open fields in the middle of Lincolnshire, and they just literally crop every square inch of that field with no inference from game birds. So it is still the actual holding got taken into account and counter characteristics. But I must stress, the parties must put that evidence to the arbitrator.
Okay, and Edward, one of the most important bits of evidence in an AHA rent review is the budget, is the productive capacity and related earning capacity document, which is the budget, which we would presume in this case the tenant would be presenting to the arbitrator. But how will the arbitrator tackle the situation where the landlord doesn't think that a budget is necessary or important? How do you think that will play when he's got a tenant's budget or she's got a tenant's budget and no landlord's budget?
Well, I think one party that goes into an arbitration without producing budgetary evidence would be unwise. The formula in Schedule 2 is very, very prescriptive on what it says is required, and it refers to the productive capacity and the related earnings capacity, and that's given equal weight to comparable evidence, as well as terms of the tenancy and other relevant factors. And going back to your game damage, that's clearly a relevant factor. If there's an ongoing problem there, that would be factored in by the arbitrator, as would the lack of repairs. And so generally, when you determine you come to an award, you look at all that evidence and then you make a decision. And if one big chunk is missing from one party, you're inevitably going to weight your evidence towards the party who's producing that budgetary evidence, because it makes you think, well, the landlord's concerned about the budget, therefore he's not producing one. Therefore, actually, the tenant's more likely to be right.
I mean, you use an interesting phrase there, which I think we should just highlight. You said equal weight. The budget and the comparables have equal weight, which plays to what the landlord's been saying in this scenario, that the comparables are more important than the budget. You would disagree with that?
I would, and in fact, about 18 months ago, I dealt with a rent review for a tenant in a big estate, and we got the rent down for that tenant, and we had exactly that from the landlord. So everybody else is agreed to stay. The rent should stay where it was. And I just said, well, I'm just sorry, I don't agree with it. Here's the evidence. And faced with the threat of arbitration, the landlord backed down and agreed the reduction.
And Ellie, just in terms of the budgetary evidence, the TFA is aware of a situation of one of our members who was involved in an arbitration and had an agent acting on their behalf. And the landlord didn't put in a budget, the tenant did, and the tenant's budget was actually showing a loss for the holding. But the arbitrator said, well, I don't know what to do with this budget because you haven't told me what I'm supposed to do with the negative budget. Does the arbitrator need to be led to that extent in terms of the process?
Oh, yes, they do. You can't, I keep using the term waving a magic wand. An arbitrator's not there to wave a magic wand and do the work for you. You've got to put it into context. And just backing up what Edward had said, even you said, if your view was, I do not accept that budgets are relevant because, the argument about the budget is you tweak one figure and get a considerably different figure at the bottom right-hand corner. And if they argued that, but if you went in and did not put in any budget at all, or didn't even demonstrate to the arbitrator what could happen, you're weakening your case. And it's the same with comparables and how you present those. You've got to make the arguments to the arbitrator. The arbitrator can say, I have heard what Mr. Briggs has said, and I place more weight on it than what Mr. Allwood has failed to say to me. You have to give that. You've got to give the arbitrator the ammunition, shall we say, to come back reach the agreement.
I think in that scenario, George, the arbitrator needs to say, okay, well, you've got a loss-making budget. Well, so what? How does that relate back to the rent you're proposing? Because both parties have to give their view of what the rent properly payable should be, and there needs to be a cross-reference to how that feeds in and how that compares with the comparable evidence, and there needs to be an analysis of it. And the evidence that we get sometimes can vary significantly. Some can be really, really good, and other evidence can be truly poor.
It's a bit like when you were at school and you were doing your math questions. So long as you can show the arbitrator your workings out, how you get from A to B, then you're likely to get a fair hearing. Yeah,
exactly.
So, George, can I just add to that? And I think it's very relevant at the present time, and given even in this scenario where we've seen quite a lot of rent increases, where they have been reviewed, not every rent has increased, or rent standstills. And now we're in a scenario where we may be saying maybe rents need to fall. Using budgets to say, well, that comparable evidence was settled a year ago, 2 years ago. using budgets to show, well, what was the forecast budget profitability at that time, 2 years ago, a year ago, etc., and moving it forward to today's prices and, where we are today, even compared to where we were at the last webinar with what's happening in the Far East and impacts on input prices, etc. Using that budget to show how that variation happens could actually also put comparable evidence into context of how things have moved since then as well. So budgets are very, very useful, but you've got to make your arguments to the arbitrator.
There's a point here which I'll just refer to in passing from Andrew Harrison, just about game damage and the impact it can have on a farm. And Andrew says he suffers quite a lot of game damage, particularly on their oilseed rape crops, where the landlord's agent always tries to abrogate the responsibilities to the shooting tenant rather than take it on board themselves. That tends to muddy the waters. Shooting tenants aren't prepared to pay for the crop destruction. But there's usually an area of thinning, and it could be £10,000 a year is lost in terms of the output. And Andrew's saying, how do you resolve that question? Now, obviously, we could have another webinar talking about game damage and how you deal with that as an issue. But in terms of the rent review, surely that's a relevant factor that needs to be brought out.
It is, and I've acted for people who have similar problems, and when you come to the most common one I've come across is actually deer damage and the inability of the tenant to control the deer because there's a prohibition on it. And then that's a relevant factor because you might have a wonderful crop of wheat, but then the deer come along and will wipe it out. And that's what the hypothetical party, the prudent and willing tenant, would be aware of when they're making their hypothetical bid for the rent properly payable. They'll say, well, I'm not going to get this full crop because it's going to continue to be damaged.
Do you agree with that, Ellie?
I do indeed, and I think game damage, we don't want to stray off onto that soapbox of game damage claims, but as part of it, we talked about the representatives making their case to the arbitrator, but from the tenant, if you've got game damage, putting up simple net fences, etc., photographic evidence and proving with and without netting, so that you've got assisting your own agent in providing evidence to the arbitrator of the impact of that game damage on your field. Photographs, we've all got telephones, take photographs of birds across the field or deer. Because I agree, deer, even sleeping, don't they, eating, people eating seeds, etc.
So let's say, so we've gone down the arbitration process. The evidence has been presented to the arbitrator. The arbitrator has had the opportunity to hear the parties and then comes down to make an award. What happens about all of the costs here? So there's the tenant's costs, there's the landlord's costs, there's the arbitrator's costs. The arbitrator may have a legal assessor of those costs as well. How are those costs split between the parties? Ellie, do you want to go first on
that? I have to. We haven't mentioned Calderbank offers. These offers where you put a label on it, a heading on it, without prejudice, save as the costs. Anything that's labelled without prejudice, the arbitrator can never see if it's relevant to this dispute. If it has without prejudice, save as the costs, then the arbitrator doesn't see that correspondence until he or she's made a decision as to the rent, and then you can reveal and say, well, on the 1st of February, I made an offer to settle the rent at £31,000. The landlord could have accepted that. We wouldn't have had all these costs. And if the arbitrator's awarded at that level or below, you've won the arbitration. And we will normally say costs will follow the event. If a party's been extremely difficult, etc., and prolonged arguments, picked up facetious arguments and run with it and increased costs, then the costs may be split that way. But normally on a rent review, there is usually a winner or a loser. If neither side have made Calderbank offers or they're too far apart, then the arbitrator then has to take a view as to splitting them. But it usually follows the event for that one.
Edward, are you in the same space on that?
Yes, this wonderful phrase "costs that follow the event" is well used. There is an issue about a near miss. Is a miss as good as a mile? If you settle a rent at 50 or 51,000 and you've called a bank at 50,000, should you get a portion of your costs? It's a difficult one, that, and generally the principle is a miss is as good as a mile. So you have to get within, you have to demonstrate that you've benefited by going to arbitration and effectively you've won. That's the principle. And then when the cost award comes, which follows the final award before costs, then the arbitrator will invite submissions from the parties and that's when the callback offers are given to them. And then he makes a decision, and he will look at, as Ellie said, they'll look at the conduct of the parties, and to see whether the parties have behaved reasonably or not, and all of those considerations. There is an ability, sort of earlier on, to cap costs if the parties request it, and it comes back to if you've got a small rent review and you've got lots of legal people involved in it, is that really a reasonable cost element, and should the cost be capped? And generally arbitrators will give the parties an opportunity to consider that and discuss it before the main process starts. So if that is agreed, there can be a cap on the costs as well.
So just to be clear, that cap applies to your ability to reclaim costs from the other side. So you might have loads of costs that you have to pay to your side, which aren't capped because you've agreed to pay those, but it's the extent to which the other side can charge you for their costs.
Yeah, exactly. You can say, well, we'll cap it at £10,000 or something. Yeah. So, that sets a limit of it.
So just two things, maybe each of you can deal with one of them. Two things that might just play to this mantra of costs following the event, as you've said. So if you don't win the arbitration, you get all of the costs. So there's two issues I just want you to address that might change the view on that. One is proportionality. So if let's say a landlord has brought a QC, a junior counsel, 6 experts, and you're the tenant just with your land agent, and the rent's £3,000, is there an issue of proportionality that an arbitrator could look at? And then Ellie, in a moment, what about the conduct of the parties, particularly with the code of practice, the landlord and tenant code of practice that we've got? And I would venture to suggest that the landlord here perhaps has not been very in keeping with the code of practice. And is that something that the arbitrator could take into consideration when settling the rent? But Ed, you do the proportionality. Ellie, you do the code of practice.
Proportionality, exactly. It can be a problem because there's undoubtedly some tactics by normally a landlord to try and bully a tenant because they generally have a bigger budget than the tenant does. And that is absolutely reasonable for the arbitrator to consider, and the arbitrator will generally in the process say, well, will consider this in the question when it comes to dealing with the question of cost, because I don't think this is all necessary. But particularly in a hearing, do you need lots of people involved in it? You might do, depending on the complexity. But if it's a simple 200-acre holding, well, with just a house and some land and a few buildings, then clearly you don't.
And Ellie, on the code of practice?
Yes, we'll take it into account. I mean, it's the landlord is using tactics here. I think the agent's on the verge of breaching or starting to breach the code, but probably hasn't quite gone far enough. I think as fellow child surveyors and fellow Association of Central Association of Agricultural Planners, we're very keen to make sure that our colleagues are acting appropriately. As arbitrators, we have a duty to report, especially to the RSS, if people aren't acting appropriately. So, we are duty bound, and we will remind each other, and we will refer to that code. But I know I've had clients say, we've got to report them to the RSS, they're doing this wrong. I said, well, no, it's a tactic. We know how far you can go, but you can't mislead, you can't lie. And where it can be a difficulty for an arbitrator is where one sees some cute stroke sharp practice from one side who's represented by a professional, and the other side who isn't. And it's that balance between we're not there to advise the unrepresented party, and you can see them making, quite frankly, stupid mistakes. And you're thinking, why are you not a member of the TFA? Why don't you talk to, NFU or somebody? Just take some other advice. Even the RICS have I think you can have half hour of advice. And sometimes you think you're not helping yourself. This evening's talk has been quite tactical and quite heavy. But for surveyors and agents, this is our business. This is what we know what we're doing. Nothing that we've talked about we say is rocket science for us because that's our business. That's what we're there to do. So I wouldn't want the tenants to be off-put by thinking, my God, I can't cope with this. There are people you can go to help, and you should not be put off, from taking that advice.
So, in terms of your experience, Ali, how many rent reviews have you been involved in, and how many have you been involved in where the tenant's been able to get a reduction?
I did. I've done probably 4 or 5 over the years. I did 2 same tenant consecutive rent reviews. And I've used the term, there are parts of Lincolnshire which are very unsexy. And it was in a very unsexy part of Lincolnshire, a house, buildings, land. Nothing. There was no diversions when we got that one down on budgets because it was coloured blue on the plan. So of course it was grade 1. No, it was not grade 1. You stand in that field and the bog oaks coming up, etc. So it was a bit of practicality rather than a textbook. It's coloured blue and a bit of paper, therefore it's grade 1, therefore the rent must be. We actually got a bit of practicality into it and budgets and got it down that way.
And Edward, in the current climate, do you think there's scope for tenants to be able to argue for reductions?
Well, undoubtedly, this is probably the climate where it's more likely to be justified. I mean, I've done a few in my time, but they're not many that have had. But I don't think in my working career, I don't think I've seen a climate quite like this, particularly in the arable sector. And I suspect that the landlords are going to come back on the houses and on the diversification and that sort of thing because they know that the land is difficult. But that, interesting enough, they won't proffer any reduction on the land. And so I think it'll be a brave landlord to be pushing for a rent review at the moment.
Okay, well, we're nearly out of time. Just a couple more questions. There's a couple have come in on the chat. Maybe you can just answer these quickly. Edward, as you're on screen, I'll put this one to you. Do arbitrators encourage preliminary hearings that deal with fundamental issues and therefore those reduce costs? Is that one?
Yeah, we do always try and have a preliminary hearing. And the advent of Teams has been fantastic because you can do it properly. Where sometimes we were trying to do it on conference calls, which was never satisfactory. But we can say, well, what are the issues in dispute here? What can we deal with as a preliminary issue? And we can go off and address those issues. For example, jurisdiction or disclosure, those sorts of things. Has the landlord got to disclose? Has the tenant got to disclose? Those sorts of things, are readily suitable for being dealt with by preliminary matters.
Okay, and Ellie, a very quick one for you. Can the tenant's labour be put into the budget, or does it have to come out of the margin left?
I'm afraid margin at the end. There's no automatic right to a living wage out of a budget, I'm afraid. But yes, it comes out of the share at the end. And that's why it is not carved in stone that you split, if there is a profit, 50-50 with a landlord. That is not carved in stone. That's where you take your own return from.
Okay, and final question, Ellie, I'll put it to you. So you had the arbitration, you've had the award, you've had the award on costs, you're not happy. Is that the end of the road?
I'm afraid so, unless the arbitrator has erred in law or in conduct. I'm afraid you can't just say, I don't like their decision, I'm going to appeal it. So it is a binding decision. There are strict procedures to follow if the arbitrator has purposely or erroneously ignored evidence, shown bias towards one side, etc. But I'm afraid if you don't like the answer, that's not good enough just to appeal it.
Okay, I think we're going to have to draw it to a conclusion there. Huge thanks, Edward. Huge thanks, Ellie. Your expertise tonight has been fantastic. In fact, your expertise in both webinars have been priceless. So thank you so much for being so generous with your time. And I would certainly encourage anybody to go back and look at webinar 1 to see what we discussed then, and then watch this one back again to see how that's played through. So huge thanks to you both for your expertise tonight. Thanks again to Roy Thorne's solicitors, our sponsors for tonight and for our virtual series. Next month, we are absolutely thrilled to say that we've got the Farming Minister, Dame Angela Eagle MP. She's going to be joining us as our guest speaker for our webinar on Wednesday, the 15th of April. So book in for that. It's going to be a popular one. Wednesday, the 15th of April at 7 p.m. It's a great opportunity to hear her views on what the government are doing and what the policy is for our country going forward, particularly for the tenanted sector. And you can ask questions as you have done tonight on tonight's webinar. So yeah, Wednesday, the 15th of April, 7 p.m. Put that in the diary with Angela Eagle. Go to the TFA website, www.tfa.org.uk, for more information about that. And you can register for that free event. But really do hope that you found tonight's webinar helpful. Do watch it alongside the first webinar, which is on our YouTube channel. And we look forward to seeing you again soon. So good night.